Three, to be exact. One is out on bond and two are in custody. Which one do you like to?
Dealer's choice.
Sounds good. I'll take on, I guess, the bond one first. It's Mr. Macero Barcenas, Judge.
Barcenas.
He's the one who was offered the decision-making class. I told you yesterday that I believe that he had to class, and I was going to help him take it.
Oh, yeah. Okay, did you get it?
So I just spoke to him. Apparently, he hasn't started yet. He didn't know how to access it, so now he's in the process of actually taking it. So I have helped him.
This dude was given a simple lifeline. A decision-making class in March. It's now the end of April, and he still hasn't clicked start. The judge isn't having it.
Get into the class to actually...
Is he here?
He is here, Judge. He's sitting in the back.
He's hacked since March. The class was offered March 4th. We're now 4/29. We've literally given him more time, at least two times. And he still hasn't done anything?
I think maybe it was a miscommunication on what...
No. I'm going to roll him day for day until he gets...
The judge just put Barkas on the clock, finish the class today, or show up again tomorrow. And again until it's done. This is legal Groundhog Day.
Doesn't get it done, then he's just going to have to... Tell him to get it done today.
Yes, sir. Absolutely.
And roll him to tomorrow. And if he doesn't get it done, then I'm going to roll him to the next day. And then at some point he'll get it done. Then he'll know that we're in business.
Sounds good. Thank you.
Unacceptable. Okay, who's next?
The next one, Judge, is Mr. Noel Dominic.
And you, if you're not here tomorrow, you don't have to come. That's why we have it, so that's okay.
I'm here.
Okay, all right. Because I don't want you to have to take extra time.
Yes, sir. Thank you.
Yeah, okay.
The next one's in custody, Mr. Dominic, Judge. Noel Dominic.
Okay.
This is, he's actually wearing a PC in this case, Judge.
Last name is Noel?
Dominic. D-O-M-I-N-I-C. I believe he is.
Why do I not see that?
I'm sorry, Reina. I'm sorry. I don't know why I put Dominic. It's Reina. Reina.
Okay, there we go. Rain. Okay. You ready?
Yes, Your Honor.
This is a new case, right?
Yes, Judge, from last...
Let's do PC.
All right, Judge. On April 19th, 2025, in Harris County, Texas, an officer conducted a business check of an Exxon gas station. The officer observed a motor vehicle at the gas pump without a front license plate and with the brake lights on. The officer observed a male asleep behind the wheel in the driver's seat. The officer contacted the defendant and observed him to have red glossy eyes and a strong odor of alcoholic beverage emitting from his breath and from his person. The defendant initially refused to obey verbal commands texted
I
the vehicle.
remember this. We did do this. And they saw him
On the
through
camera.
surveillance driving into the thing.
Oh, I see. I guess I didn't see in the damn sender.
That's what I remember this because I had the same issue with you until they told me that they have video surveillance of him pulling into the station.
When is the surveillance video say that? I guess how much time before the cop got there? Because I saw the police.
That we didn't get into like the...
No front plate passed out at the gas pump, smells like alcohol, eyes like a stoplight. At first glance, DWI, right? But the defense wants proof he actually drove while impaired.
Like how, and
Gotcha.
all I know is that they've got video of him going in and that's why.
And the reason why I was asking, Judge, because I found a case that's actually strikingly similar. It's from Austin, but it is strikingly similar where they found the toilet profile, no probable cause. If you like, I can...
They have him on video pulling in?
Well, no, Judge, but it does talk about how it's... I mean...
I'm with you
Yeah.
until that point.
Okay. Even if they have operation, I don't know how to get intoxication. That's the issue. There's nothing, no signs about intoxication other than a sign of introduction of alcohol into his body, but nothing about
They
intoxication.
pull him out and he's got all the signs though, right? If I remember?
Strong odor of alcoholic beverage
Yeah.
emitting from his breath and from his person, appeared to be disoriented, red glossy eyes.
And he's asleep.
Right. But red eyes, what could be many things, and then, I mean, these are factual issues. I get that, but from what I
This is
saw...
probable cause.
Right.
And you've got a guy that's pulling in, he's asleep at the pump, cops go try to figure out, hey, what's going on, displays all the factors, and then, yeah, I think that there's enough for peace.
Okay, fair enough.
Sure.
Okay, so then I got one more judge in custody.
So
peace.
hold on. So
Yes, sir.
he's at no bond because of the ag assault upstairs. He's set tomorrow Guys, on him, no, this is on Reyna, page 35. No drugs, no alcohol, random testing. Can you see if he has a license?
Yes,
sir. Let's see. Just all the standard conditions.
Judge, we,
Do you want?
we have conditions in place for RUA.
We do? We have it already? Okay. All right. I think we're good.
Despite the defense pushing hard, the judge rules probable cause stands. Being asleep at the pump plus all the physical signs is enough to proceed.
Do you want to set it for later this week to see what happens? Or do you want to do it far off? It's up to you.
No, let's see what happens, Richard. It's okay. I just wanted to maybe quick reset. Yes,
Yeah.
that's okay.
Okay. Who's the last one?
Last one is Rivas, Judge. He's also in custody. And this is the one I approached PC late, yesterday because I was pointing late. We're
Okay.
talking about that there was nothing in the names about knowledge, that actual knowledge of falsity.
You have anything?
So what I found is nothing specific. There's been no case law specifically addressing that issue. But from what I found is that there is case law regarding the element of knowledge, where it has to be actual knowledge. Mere possession of an item is not enough to provide any type of actual knowledge, at least as prescribed under the statute. The statute controls, the language of the statute controls and explains.
Ladies, can you take a look?
Yes, sir.
And then I can just take a look and pop with them real quick, and then I guess let me thin the line and then we can explore it further. Okay, can you give me just a couple seconds? Let me thin them out because it's gonna take a little bit longer. Hey, sorry, you can reset John so you didn't have to wait.
Yeah, but, I reset and then he said that you wanted to.
Yeah, I'll monitor these. Okay. Hey,
Judge.
sorry to keep you waiting.
No, it's just.
Here's where it gets nerdy, but real. Can you be charged with possession of a fake ID without knowing it's fake? Defense says no way. State says the thing unglued in the cop's hand.
So I'm just reapproaching again on Rebus, the ID case.
Oh, okay.
So I spoke to the state, and so it seems like we're at disagreements on this. And the argument that I have, Judge, I think I have something that is pretty compelling. There's a case law that I have called Fledging v. State, and that's not regarding an ID, it's regarding a check. But the court looks at the element of knowledge in it, and it talks about how possession of that forgery check is not enough to meet knowledge because mere possession alone is not enough. It's similarly here, by analogy, a possession of this ID is not enough because it would create an absurd result. The purpose of reading the statutes is that the court must interpret it by its ordinary language. And the language says that it has to have knowledge, actual knowledge of its falsity. Now, if for some reason it's ambiguous, then it must be interpreted in a way that doesn't produce an absurd result. So if we interpret it to mean the way the state is interpreting that mere possession is enough, then it would basically allow the police to arrest anyone that has an ID that has any type of dimple or any ripple or any type of defect in production, because that's what's happened here. The police officer's only basis for arrest was that the texture of the ID was wrong or different than what he's.
That's why they do licenses in special ways so that officers know that they're fake or that they're real or fake, right? They have little so they can sit there and they can do this. It's got special colors, special, diagrams on it to be able to ascertain whether it's fake or not. And in this case here, there's a piece of tape and the paper's kind of like coming off.
That's not what I actually read in the DIMS. So the police officer in the DIMS only says that the texture was off. That was not what he was used to. But my point is kind of emphasis on that point that even if it is produced in such a special way, production can still be defective for whatever reason, and that shouldn't subject you to deprivation of liberty.
But at that point, that gives the person the right to investigate more. When something is amiss, right? That's the reasonable suspicion, right? The thing that gives them the authority to investigate further to see, hey, is this legitimate? Because if it was legitimate, then they send them on their way.
Agreed. But it gives the police right to investigate further for to arrest. And that's the thing, that the state would need to find that there is suspicion for every element of the offense, and it's the state's burden to produce that. And they haven't produced anything to show that there was reasonable suspicion for the actual knowledge of falsity.
State.
So, Your Honor, a couple things. One, this was something that the officer again felt. It's not real. It easily became glued. The officer's going to be able to testify that, well, this was not something that came to the Texas Department of Motor Vehicles. In fact, the defendant even said, yeah, I don't have a license. Mine's suspended. Lack of knowledge of the law is not a defense.
Right.
Coupling all of
Ignorance
that
is never a defense, right?
And I would argue, Your Honor, we're not saying this is just mere possession. We're not arguing that. We're saying if you take a look at all the facts and circumstances surrounding this case, there is overwhelming evidence that there was intent by the defendant to use that driver's license because he gave it over to the officers when they responded to the accident. They easily could tell it was fake. It even
Pro tip, fake IDs don't usually fall apart on contact that. What the officer says happened here, whether it sticks in court, is another question.
unglued on scene. So
There's enough unglued on scene.
The thing is that I don't see that anywhere in the DIMSA being unglued.
said,
And the fact is that this
also noted that this did not have the same texture, was not laminated, or it was laminated, but was not issued by the state. Card easily became unglued while holding it and was clearly made from paper and laminate.
I think that there's enough to go forward.
Okay. All right. Sounds good. All right. Thank you.
For sure.
Judge, I'm here on Mr. Jerome Hunter. He has that BVR that you put on today's docket, so we can address.
Come up, Mr. Hunter.
Judge, his mom is also here. Would it be all right to have her come up as well? Judge, if I may? I explained to Jerome and his mom that the reason why he's here is because there was a reading from that he was past his 9 o'clock curfew on the 15th. I talked to him about it. He's a young man that actually has a pretty good future, Judge. He's got a football chance in college. Both he and his mom knows the severity of, your words in terms of him being home at 9.
She would be ashamed to ruin a potential football career because of criminality, wouldn't it?
So anyways, Judge, on that particular night, what had happened was it was still during football. I think football is over with now. So he made the mistake. He went out to go work out with football with, is it your cousin?
My cousin.
Your cousin. And that's where he was that night, Judge. I asked him if he could get something from the cousin. He's got some text messages going back and forth of them meeting at a park by the house, at a park to work out. And that's that. And I think that's the only violation he's had, Judge. I think both his mom and Jerome realized that, hey, cannot happen again. His mom tells me that she would definitely, he's never been in trouble,
Let's do this. I'm going to send you for a drug test, Mr. Hunter. Okay? Send him for a drug test. You're to come back, and then we'll go from there.
Yes, sir.
Okay? All right. Just take a seat for me. We're going to send you right now.
Back there or any?
Just, it's fine. Yeah.